This is a judgment of Supreme Court in which two concurrent findings by the trial court and first appellate court, that is High Court, both concurrent findings against the accused holding guilty of murder and sentencing them to life imprisonment was set aside by the Supreme Court, whereby acquitting the accused persons. Before dealing with the merits of the present case, that why the accused persons, in spite of concurrent findings of the court below, the Supreme Court interfered in extremely constrained and confined jurisdiction under Article 136 of Constitution of India. The answer lies in the decision of the court. And before dealing with that, I would like to tell my viewers the settled legal principles of law which has been again reiterated by this judgment. Number 1, that in view of section 134 Indian Evidence Act, it is only the quality of evidence that matters and not the quantity. As a sequitur, it was held even in case of murder, it is not necessary to insist upon a plurality of witnesses, and the oral evidence, even of a single witness, if found to be reliable and trustworthy, could lead to conviction. Then the Supreme Court secondly dealt with an issue that oral testimony of a witness can be classified into three categories. Number one, that witness is wholly reliable. Number two, the witness is wholly unreliable. And number three, when witness is neither wholly reliable nor wholly unreliable. So, qua these two categories of cases, there is no serious difficulty in the court for arriving at a conclusion whether to believe a witness or not. But in case of third category of cases, when there is the witness is neither wholly reliable nor wholly unreliable, the issue arises before the court. And in those cases, as a rule of prudence, the court would be extremely circumspect and look for corroboration of any material particulars by reliable testimony, either direct or circumstantial, meaning thereby, in those cases, the testimony of the witness, as a rule of prudence, has to be corroborated by reliable testimony, whether direct or circumstantial, of any other evidence or witness. The third proposition of law, which is well settled, is that defensive investigation is not always fatal to the prosecution. If defective investigation is done, but otherwise the ocular testimony is found credible and cogent, then in those cases the court has to be circumspect in evaluating the evidence. A faulty investigation can itself is not a determinative factor to throw out a credibility of prosecution witness. Then number 4, the non-examination of the investigation officer in every case must not result in acquittal of the accused, but it has to be shown that non-examination of the investigation officer has resulted in prejudice to the accused, and in case if no prejudice is caused, mere non-examination would not render the prosecution fatal. And number 5, settled principle of law is that discrepancies do creep in when a witness deposes in a natural manner after lapse of some time. And if such discrepancies are comparatively of a minor nature and do not go to the root of the matter of the prosecution story, then the same may not give any undue importance to or benefit to the accused. Now let us see the factors which have been weighed by before the Supreme Court while acquitting and setting aside two concurrent findings of conviction in murder case. The accused were acquitted, they were set free. Now, the first ground was because there was animosity between the witnesses who deposed for prosecution and the accused persons. There was enmity of 10 years prior to murder of one person, Narayan, who was murdered in this case. And the appellants who were the accused before Supreme Court testified when their 313 CRPC was recorded that there was enormity, and the same prosecution witness who is deposing now in murder trial against them, they have deposed against him when there was a dispute under 145 CRPC regarding property. So it is evident even from deposition of PW2 that there was long standing quarrel between the parties. And as such, by 313 of the accused persons, it was clear that PW2, who was a star witness of prosecution, was trying to falsely implicate the accused persons so that they remain behind the bars, and thereby indirectly it would end to the property dispute. The Supreme Court had held that this type contention of the accused person cannot be brushed aside completely because there is uncontroverted evidence of a continued enmity of 10 years preceding the alleged murder of Narayan between two groups. So it could be established that PW2 nurtured personal ill will towards the appellants, and the possibility of PW2 having acted with intention to keep the appellants away from legal proceedings as well as interference in property rights cannot be totally ruled out. Hence, PW2 being inimical to the appellants, his testimony has to be taken with a pinch of salt. And for that reason, deeper scrutiny of the other evidence on record is also required as per settled principle of law. Then there are two witnesses, eyewitnesses PW2 I have dealt with. Then other witness PW3 was a chance witness, and was held by the Supreme Court that it is not clear from the testimony of PW3 as to why so early in the morning he had the occasion to pass by the place of occurrence. It was found that PW3 is a resident of Nevadia Police Station, Kudaganj district, Shahjapur, whereas PW happened to be a resident of Fatehpur Bujurg Police Station, Tilhar district, Sajanpur. It was held by the Supreme Court that the distance between the two places is around 1 to 2 miles. The incident of murder happened within the jurisdiction limits of police station Tilhar. It has not surfaced from the evidence of PW3 very clearly from where he started and where he was headed for. The Supreme Court had held that to prove the guilt of the appellants beyond reasonable doubt, as it is settled in criminal law that the guilt has to be established beyond any reasonable doubt. If there is any reasonable doubt, then the benefit has to be given to the accused and the accused has to be acquitted. So in this case, the Supreme Court had held that some more particulars were required given the circumstances that PW3 was at best a chance witness. The Supreme Court also held that there is an apparent inconsistency between the versions of PW2 and PW3 insofar as the role attributed to Shiolal by PW3 is concerned, which can hardly be overlooked. The Supreme Court had held that the testimony of PW2 and PW3 is not free from doubt, and their evidence not being of unimpeachable quality, the rule of prudence would demand a corroboration of their version from other witnesses who, according to PW3 and 3, were present at the place of occurrence and witnessed the murder of Narayan. The three persons were named as other eyewitnesses, but prosecution did not examine them, leading the Supreme Court to draw an inference that had they been examined, remaining three witnesses who witnessed the murder, the prosecution story would not have been supported by them. Then the Supreme Court held not only three eyewitnesses were not examined. Dr. Hanif, to whom PW2 had approached and allegedly narrated the incident of murder from being transcribed into a report, that is FIR, then that Dr. Hanif had taken down the versions of PW2 in writing could not be produced by prosecution have not been examined. The Supreme Court had held that Dr. Hanif could have been deposed by him, but in the absence of thereof, a cloud of doubt is formed for which the Supreme Court again compelled to draw an inference that Dr. Hanif may not have been in the picture at all. Then PW3 161 CRPC statement was recorded nearly 24 days after the incident, and even the investigation officer of the case did not enter the witness box. The appellant's accused did not have the occasion to cross examine him and thereby elicit the reason for such delay. Therefore, the Supreme Court had held the delay in recording the statement of PW3 in the course of investigation is not referred to and therefore remains unjustified. The possibility of PW3 being fixed up as an eyewitness later during the process of investigation cannot be ruled out.